So hello everybody, I'm Neelu Berry Chowdhury. I'm going to go through the Lloyds Banking Group, Bankers, HBOS, Halifax Bank of Scotland, Criminal Appeals Court judgment. And this is called 2020 EWCA Crim 369 of 28th of February 2020. And we only need to, there is a, they're saying reporting restrictions may apply, but that's only if, there is any breach of privacy data for anybody. So we only need to look at the first 5 paragraphs. So all it says, what we're looking for is that 200 billion a year was laundered by UK banks, according to Anthony Stansfield, ex-crime commissioner of Thames Valley Police, who was present at these hearings. And what it says, that they tried to reduce their sentences. So they were prosecuted under these various laws. So, for example, fraudulent trading is contrary to Section 458 of the Companies Act 1985. They got 3.5 years for conspiracy to conceal criminal property or proceeds of crime. And that's contrary to Section 1 of the Criminal Law Act 1977, and 3.5 years imprisonment concurrent. Conspiracy to corrupt, and there's also concealment of concealing of criminal property is another 6 years imprisonment for that. So that's all we need to know from this, okay? 7 years imprisonment, etc. So basically, once that the Criminal Appeals Court of Appeal Criminal Division, once they have sat in 2020 and stated that these crimes are criminal offences, that's a precedent. That means if anybody ever fraudulently trades, which all banks we know are fraudulently trading, the bailiffs are fraudulently trading, the police are fraudulently trading, because they're aiding and abetting the bailiffs to fraudulently trade. And the Home Office is fraudulently trading, the Justice Minister, the Finance Minister, the Foreign Minister, because all this money has been laundered abroad. Okay, that's all we need to know, is that actually just that first paragraph. And the next one I'm going to look at is the Leighton judgment. So this is the Leighton judgment of September 2023. Wayne Leighton, the claimant, was being pursued for council tax whilst he was abroad. His tenants were liable for it. He had over 30 attempts by bailiff company Bristow and Suter to, even at his parents' home, to try to recover this fraudulent debt. And the first paragraph sums it up, first 2 paragraphs, that the defendants were breaching the paragraph 66 of the Tribunals and Courts Enforcement Act 2007, harassment, breach of Statute of Marlborough, and breach of commercial lien. So this is what Wayne Leighton used. But through the proceedings, what was apparent was that these liability orders had been generated by the local government and as if they'd been issued by the magistrates in the magistrates' court. So the local government impersonated the magistrates. And because the file of the council tax file was not retained at the magistrates' court, therefore there was no right of appeal. The right of appeal was denied. And in a democracy, in a justice system, you are allowed or mandated 2 rights of appeal. You can appeal a decision. So if it's a magistrate's court, it goes to the Crown Court. If it's a county court, it goes to a high court. Now, what these bailiffs are doing is issuing just printed paper without any consideration by any judge. And then these bulk liability orders were, so if I type in liability order, so they're talking about 4 liability orders. So there were 1,700 liability orders in a bulk. The magistrate stamped 1 and signed 1 of those, and so none of those files. So what is wrong with the Leighton judgment is that the file, that those 1,700 liability order files, these 400, these files were not retained in the court, so the right of appeal was denied on those occasions. The councils are doing, every council is doing this every fortnight. They're doing thousands in bulk, and they're not stopping doing that. So all these bailiffs that are coming, they are doing exactly that. Is they are doing these, generating these fake documents, as we saw at the lodge. The seal was generated on a computer. It was not generated in any court. So, I mean, here, the judge is saying the City of York Council are not party to the proceedings, but they should have been added. And the judge did not write off those 1,400 liability orders, and he should have written off all the liability orders as going back in time from when the councils were set up. And so this is why there is an appeal. So I'll go to the appeal in the Supreme Court, which is pending. So this is the appeal drafted October 15th, 2023. And if we type in the word liability orders, so they're saying, whether the liability orders are invalid. So old documents. So these liability orders apply to parking fines, speeding fines, to child maintenance, family courts. These are all done in the same bulk orders. And so all the arguments apply that when these bailiff companies or the local governments are issuing these documents, the right of appeal is denied. So there's a serious flaw because of the right to appeal being denied. So we have all these various laws. So we've got, say, Section 12 of the Administration of Justice Act. Proceedings entailed a decision raising point of law of general public importance relating to a matter of national importance. Result of proceedings is so significant that the hearing at the Supreme Court is justified. And so we have the paragraphs 26 and 66 of the Schedule 12 of the Tribunal Courts and Enforcement Act 2007. So if you want to look into those laws as to why the liability orders in England are all fraudulent. Sorry about that. And that's it. So we have, this is a High Court draft of legal argument into the Supreme Court as to why the judge in the Leighton judgment, even though Wayne Leighton did not have to pay any council tax, and he got £4,000 damages for the attempts by the bailiffs to get money off him, which was not due from him. That what Wayne Leighton is saying, that all liability orders should have been written off. They're all voided, and that they should be, you know, basically refunded. Article 6 of human rights, etc. So, you know, Judge Lord Harrison recognized the process was flawed, but did not really compensate the victims of fake liability orders. Okay, so they've raised these issues before, and it's been in Parliament. So we're making the government ministers address these issues that have been dealt with in the High Court, and now they're pending in the Supreme Court, whilst these bailiffs are carrying on in contempt of even the decision in the High Court that said these liability orders in bulk are not enforceable. Okay, so any document that has been issued by bailiff companies and not by a court. So if a judge issues an order, then you have to go and have a hearing. Nobody can spring an order of a court without you having been heard. So if you haven't been given notice, you have to be given 4 clear days of notice of a hearing, and you have to have the opportunity to put in your side of it as in a defense. Then it becomes a criminal robbery because it is in contempt of these previous convictions for fraudulent trading, concealing proceeds of crime, and conspiracy to conceal these proceeds of crime. Okay, I hope that helps to understand that we are not in defense mode with any bailiffs. We are in attack mode, as in the precedents of Leighton and Lloyds judgments make them fraudulent traders, pirates, in other words, and robbers and thugs and criminals that should be locked up, the same as the bankers. Okay, thanks.